We have one last pre-trial where I'll try to suppress your statement. Scott, if I'm unsuccessful...
No, I'm not taking manslaughter, Bobby. Please don't ask me that again! I'm sorry, man. It's just getting to me.
Okay. You understand the risks?
I do. So what? We go in the morning?
We argue the motion. Trial starts after lunch. Eugene will be with me.
Okay. You know, I keep having this the dream where everybody wakes up and comes to their senses. And Karen's even in it. She's not dead.
We have a solid shot if we can shut down this videotape.
Oh, hey, see this? Fiji. That's where I'm going when I walk out of that courthouse. I'm going right to a travel agent. In 10 days, I'll be sitting on that beach.
Look at me, Scott. Look at me. If that videotape is admitted, I believe you will be convicted. Probably of second-degree murder. Now that carries a life sentence. You will not be going to Fiji. Do you get that?
They're inside.
Okay. This thing was built to bring children joy, and it's toxic.
Come on.
The fact that they called for the meeting, that they're coming to us, it's a very good sign.
How much?
We have no idea.
Well, nothing is good enough for what they did to our kids.
Of course not. But you have to remember, if we go to trial, we will want your son to take the stand and talk about his seizures. We'll need your daughter to talk about her motor problems. And your youngest son may have to discuss his learning disabilities and the humiliation that he suffered.
We've talked to them, Eleanor. They're ready.
The number Eleanor and I think is reasonable is 160 per child.
It seems low.
Of course, nothing can make up for your children's injuries. But the present-day value of that is probably around 240 if you figure in an appeal. And given our problems proving liability, that would be an excellent settlement.
We're not sure we can get that, but that's our number.
What, you think I killed her? What, are you crazy?
I don't think you intended to kill her. I really don't.
So what are you saying?
Mr. Wallace, things will go much better for you if you cooperate.
We think you had an argument. You hit her. Maybe by accident. She was unconscious. You were afraid of how it might look. You put her in the car to make it look like a suicide. It's what happened, isn't it?
My client was in shock at the time of this interrogation. He had just found his wife dead less than an hour before this.
First of all, he was read his rights.
It isn't about that. He was suffering severe traumatic distress. He wasn't fully processing all the stuff being thrown at him here. And that tape makes it look like he was acquiescing to something when he wasn't. He was just under shock.
You can certainly argue that, counsel.
Your Honor, if the jury sees that tape, the prejudice alone...
He certainly had the presence of mind to give us a nice, coherent, exculpatory version of the events.
He gave you the truth.
All right. I'll allow the videotape for impeachment purposes only.
Your Honor, that will effectively prevent my client from testifying.
It does no such thing. It only means if he testifies, he does so with some risk.
I object to this.
Your objection is noted. The ruling is final.
Offer's still good.
No, thanks. If you take the stand, the tape comes in. And I don't know how we win this without you getting in that chair.
Now, look, I can explain that tape. Now, it was like you said, I was in shock. Now, I can convince the jury of that.
I'm gonna recommend manslaughter one last time.
No.
I have one other idea.
A polygraph?
I'm willing to box him. If we both stipulate to the admissibility, the judge will allow us to introduce the results.
Bobby, do I have the word dope stamped on my forehead, or is it just that you know me? Obviously, if you've come to us asking that we give your client a lie detector, you've already given him one and he passed.
We've given him 5 with 4 different technicians, and he's passed every one.
He took it 5 times?
And passed every one.
Suppose he fails ours. You willing to stipulate to admissibility?
Right now. This man is innocent. I've never done this before.
Done what?
Traded on our personal relationship, Helen. We know each other. I have never asked for a favor on the basis of our friendship. I'm doing it here, and I've earned it one time, Helen. I've earned it. Now, you trust the accuracy of lie detectors? Give him one. If he passes, kick it.
You want to run that by me again? Our case is circumstantial. Evidently, he has passed a polygraph over and over. His lawyer is willing to box him with our own polygraph.
Helen, the trial starts in 2 hours.
I realize that, Kate.
And you want to what? Put out a release saying, oops?
If this man did not commit the crime, I'm not going to secure a conviction simply to avoid a public relations nightmare.
Look, I saw that interrogation.
Maybe he was disoriented like he says.
You've got motive. There's forensics. The whack on the head. They were heard fighting. Nobody described the woman as remotely suicidal. The man did it. I don't care if he passed 50 polygraphs.
I'm not so sure.
Well, let me make it easy for you. You're prosecuting this case.
All right, I think it goes without saying, but I'll say it anyway. This offer in no way admits to any liability on the part of the Environmental Protection Agency.
We realize that. What's the number?
$20,000
$20,000?
apiece. Times 3, that's $60,000.
More than the case is worth. And we're only offering it to avoid the publicity that this hearing might generate.
We have children with severe learning disabilities. Motor skills...
Look, even if that thing is toxic, the government didn't manufacture it.
Yes, that's been your argument, but you lost the 12B6, you lost the Federal Tort Claims Act.
I don't think we'll lose at summary judgment.
You represented on the phone on Monday and then again this morning that a serious offer was coming in.
The figure represents the maximum authorized by the agency, so...
Then why are we talking?
Because we have faith that logic eventually seeps into even the most hard-headed of craniums.
Get out!
You're obligated to take the offer to your clients, Miss Frutt. However much your firm might end up out of pocket, ethically, you are required to present this offer to the plaintiffs.
Thank you, Mr. Myers. Our clients are low-income parents whose children have lifelong handicaps due in part to the agency you represent. You have the indecency to come in here and tell us that their injuries are worth only $20,000, and then to add to that insult, you are lecturing me on ethics? Get the hell out of here before I throw you out.
You're tilting at the wrong windmill this time.
You haven't seen us tilt yet.
How you doing?
I just went into the bathroom and threw up.
We gotta tell the clients. We should go there again.
You can't beat yourself up, Eleanor. It's a miracle you got it this far.
$20,000. What a miracle.
We should go.
When I arrived, the defendant was sitting right out on the driveway. He seemed very despondent. Inside the garage, we found the victim, face down on the floor next to the vehicle, bleeding slightly from the back of the head.
She was dead?
Yes. There was a garden hose taped to the exhaust pipe leading to the rear passenger side window. It appeared to be a suicide by carbon monoxide poisoning.
Did you run prints on the garden hose?
We found prints matching the victim and the defendant.
You said Mr. Wallace seemed despondent. Could he have possibly been in shock?
Possibly.
Did my client tell you that he pulled the hose out of the car?
Yes, he did.
And that he pulled his wife from the vehicle?
He said that, yes.
I was walking my dog at 9:30, and I heard him screaming at his wife from inside the house.
Are you sure you heard Scott Wallace?
I'm 100% sure. He's my neighbor. I know what his voice sounds like. And I was about 20 feet from his front door. He and Jill were both yelling at each other.
Do you know what about?
No. But I found out later she was planning to leave him.
Objection.
Sustained.
You're sure this was around 9:30?
Positive. That's when I walk my dog. Every night.
One last thing. You said you could recognize the defendant's voice. You could recognize his screaming voice?
Yes.
You heard him scream before?
Many times. He and his wife had a lot of nasty screaming fights. Once we even called the police.
You called the police that night?
No.
You hear any signs of violence?
No.
In fact, you heard nothing that caused you any sense of alarm?
Well,
You didn't feel the need to intervene?
No.
There were shed skin cells on the victim's head, neck. DNA analysis revealed an exact genetic match.
With who?
The defendant. We also analyzed a skin fragment found under the defendant's fingernail.
Were you able to identify it?
It was a genetic match to the victim.
If my client were trying to resuscitate the victim, it's possible that shed skin cells could get on the victim's head and neck. Right, Doctor?
That's possible, yes.
And while trying to save her, it's possible that a piece of her skin could get under his fingernail, right?
That might be less likely.
I'm asking you, is it possible?
Of course.
And all this DNA evidence we're talking about, it could have come as a direct result of my client's efforts to save his wife. Isn't that right, Doc?
That's not what I think happened.
But it's possible.
Yes, it is.
Thank you.
I can't believe it.
We were just as shocked as you are.
I thought it was going to be a substantial offer. Didn't they tell you that?
They intimated that we would be very happy. Yes.
Our suspicion is they did that to lull us a little, thinking if we were expecting settlement, we really wouldn't prepare that hard for their motion.
Were they right?
Absolutely not. We're very ready.
After what they did to our children.
The hearing's tomorrow. If we win, we think their numbers will come up.
I have to be honest and say that I am very disappointed with the two of you. We had a few people tell us that we should have never hired you, that you didn't have the resources to. But we liked you. Well, right now, I feel deceived. I feel like you promised things to get the case. Things which you obviously can't deliver.
Can I respond to that? When we took this case, we thought we would be suing the manufacturer of that play gym. That was a much stronger case. Then when we discovered both that company and the chemical company no longer existed, your case was basically over until Eleanor came up with the idea to sue the EPA. She beat them in the motion to dismiss. She got through the administration level, earning the right to keep going. I'm sure there are other firms out there that could have gotten it this far, but the reality is they wouldn't have tried. Most lawyers would have dropped this case as soon as they found the manufacturer to be non-existent. But Eleanor, and me with her, kept going out of commitment to you. Maybe we failed, but I take exception to the suggestion that it was a mistake to hire us.
We're just disappointed. That's all.
We all are. Let's just do our best at summary judgment, and hopefully we'll survive to get this to a jury.
The cause of death was monoxide poisoning.
What about the bleeding from the back of her head?
That contusion was the result of being struck with a blunt object.
You said blunt instrument. Could that instrument be a cement floor? If she fell on the garage floor, hitting the back of her head, could that have caused the trauma we're talking about?
A fracture like that couldn't have happened by someone simply falling down.
If my client discovered his wife in the car, he grabbed her, pulled her out, and as he was pulling her out, her head crashed onto the floor.
Objection.
Overruled.
Doctor, if my client discovered his wife in the car unconscious, pulled her out, causing her head to hit the floor, could that have caused the fracture we're talking about?
It's a possibility.
Thank you, doctor. That's all.
Miss Campbell?
Commonwealth calls Kyle Barrett.
This seems like a good time to call it a day. We'll begin with Mr. Barrett in the morning.
Get Mr. Barrett to my office now.
He's gonna walk?
I'm not saying that, but...
But what? He killed my sister. Don't tell me now that
Mr. Barrett, as we have explained from the start, our case is hugely circumstantial. We had hoped to be able to introduce the videotape interrogation.
And you can't?
Not unless we get him on the stand. This will only happen if his lawyers think he's losing, which I'm sure they don't think right now. Case has gone pretty well for them. The only witness that we have left that can put them in the necessary hole is you.
Which means when we ask you, did your sister seem suicidal, a response of, I didn't think so, isn't gonna do it. Also, to the extent that you talk about anything your sister told you, that's hearsay. But, under the law, one of the ways around the hearsay rule is an exception called the state of mind.
Richard.
Basically, if you can say she wanted to start a new life.
Richard. Mr. Barrett, we certainly don't mean to put words in your mouth, nor would it be permissible for us to do so. But you need to realize, unless you do damage, Scott Wallace probably won't testify, in which case he could in fact go free.
You knew your sister, sir. If she was planning to start a new life, if she was in a positive place, there is no way she would ever take her own life. Not in any circumstance. Certainly not in this situation where she was looking forward to starting over. She was murdered, if you know it. She did not commit suicide. You absolutely know it.
I got it.
We'll see you in there. First, you tell him how to beat the hearsay rule. Then you practically supply his testimony.
Helen, I'm just preparing our witness. I explain the law, tell him what's relevant and what to emphasize. I do it, you do it. And besides, you said it yourself. This witness is all we have to get Scott Wallace in that chair. Be glad I coached him.
I have to testify.
I've explained this, Scott. If you get up there, they can put in the video.
But if I don't tell my side...
We've backdoored your story. The jury knows your version of the
now,
event.
Listen to me. Now, I know I have the right not to testify, but I also know that juries draw inferences sometimes about defendants who don't. Now, I'm a credible witness. I can explain that videotape, and the jury can see me as a person.
It's a bad idea. Trust me. Miss Fred.
Can you excuse me for 1 second?
$32,500.
Rejected.
Aren't you going to make that?
We don't need to present that to our clients. And if your intent with that insulting lowball is to inflame me before we go in to argue, it's not going to work.
You seem a model of restraint.
You know something, Mr. Myers? I have a thing about smug. I don't like smug.
I know how you people work. You hustle in clients.
All right, John.
No, Mitchell. The courts are clogged by bottom feeders like you who sue without bothering to even consult the law.
We consulted the law, trust me.
Don't think for a second that after we're through here, we won't go after you for abusive process.
Let's not let our tempers prevail here. Come on.
Things just got worse. Judge Gilmore got appendicitis. The case was transferred to Judge Aldrich.
What? Judge Aldrich is sitting?
I'm afraid so.
Oh, great. He'll kick this before we even get through the door.
Let's just go for it. There's nothing else we can do at this point.
She was both excited and terrified.
Excited and terrified of what, sir?
Well, excited to be starting a new life, at being single again.
Objection, this is all hearsay.
State of mind exception?
Whose state of mind?
The victims.
Oh, come on.
Judge, they're arguing that she killed herself. The fact that she told her brother she wanted to live directly rebuts that.
I'm going to allow it. The objection is overruled.
You said your sister looked forward to meeting a man she could love.
Yes. She was planning on telling Scott that she wanted a divorce.
And why was she so terrified, if you know?
She was afraid of Scott's temper.
She told you this.
Yes. She at one point wanted me to be with her when she told him.
Why was that?
She was afraid that he might try to harm her.
Objection!
I'll allow it.
Did your sister say anything else, sir?
She said that if she turned up missing, or if I didn't hear from her, that I should call the police, because Scott probably did something to her.
Objection!
Overruled.
Mr. Barrett, you've heard speculation that maybe your sister took her life.
That's ridiculous.
Why, sir?
My sister and I talked every day. We were extremely close. She hid nothing from me. If she was in so much as a bad mood, I would see it. She was not depressed. She was not despondent. She had no mental deficiencies. And the idea that she took her own life is absolutely preposterous.
I have nothing further.
Mr. Barrett, you think my client killed your sister, don't you?
Objection.
Goes to bias?
I'll allow it.
You think he did it?
I know he did it.
And if you think this man killed your sister, you'd want him to go to jail, wouldn't you? In fact, if you had the opportunity to help put this man in jail, you'd probably jump at it, wouldn't you?
What are you suggesting, counsel?
Well, I'm suggesting you do anything to put the man you think killed your sister behind bars. You'd even get up in that witness chair and lie.
Objection. I haven't lied.
Well, I have your statement to the police right here. Taking the night your sister died. And you didn't say anything about her telling you, if I disappear, call the police. You didn't say anything about her telling you she was afraid of being harmed, did you, Mr. Barrett?
I believe I did.
Where is it? Here's your statement. Where is it?
Well, maybe the officer didn't write it down, but I'm certain...
Didn't write it down. The officer forgot to write that down.
Look, I have always maintained that your client killed my sister.
Yes, you've always maintained it. It has always been your opinion. But this is the first we're hearing of any facts. Any statements like, he'll try to harm me. This is the first we're hearing of this because you just decided to make those statements up, didn't you, Mr. Barrett?
Objection.
Overruled. You want to put that man away so bad that you got up here and lied to get the job done.
Objection.
All right, Mr. Young.
You say your sister wasn't depressed. She had no mental deficiencies. Didn't my client share with you his concern that your sister had huge mood swings, that she might even need medication?
Hearsay.
Overruled. Didn't he come to you once, seeking your help as her brother, to convince her to get treatment?
Absolutely not.
You're a liar.
Objection.
Mr. Young.
You're under oath here, Mr. Barrett.
Objection.
Sustained, Mr. Young. Don't make me warn you again.
You say your sister wanted you to come with her that night, but you didn't.
Because I didn't think he would really kill her. I was wrong.
What'd you do that night, Mr. Barrett?
I'm in a weekly card game.
Your sister told you she was afraid for her life, but you couldn't help her because you had a poker game? I think I got it.
Ms. Gamble.
Commonwealth rest, Your Honor.
Mr. Donald.
1 second, Your Honor. What do you think? Right now, we still have a chance, but if the videotape comes in... Scott, it's still our opinion that you don't testify would open a door on the tape.
But Bobby, he's lying.
You crossed him pretty good, I think.
Yeah, I want to testify.
I can't let you.
Bobby,
Scott, if you get up there, we'll lose.
Bobby.
The defense rests, Your Honor.
What's happening here is obvious. The manufacturer of the playground equipment that caused these alleged injuries to the children has gone out of business, leaving the parents with nobody to sue. So, they file a claim against the EPA. The plaintiffs have cited no persuasive case law, state or federal, that would allow for a United States agency to be sued for the conduct of a private business. And, Your Honor, let's consider the logic of what they're asking for. Since these injuries were caused by environmental factors, they're suing the Environmental Protection Agency. Under that theory, since we have an FDA, you could hold the government liable for any harm caused by a drug manufacturer. Since we have an FAA, you could sue the government for every plane crash. I understand that we live in a litigious society, but the idea of suing the federal government for the actions of any regulated private industry, that's ludicrous. As a matter of law, this claim is untenable, and accordingly, the government's motion for summary judgment should be granted.
We are not suggesting that the government be held liable for air disasters simply because there's an FAA. Nor are we saying that the EPA should pay damages every time there's an environmental crisis. We're saying, in this situation, 3 children got hurt, very hurt, because the Environmental Protection Agency didn't do its job.
So you're alleging the kids got hurt by toxic playground equipment?
Yes, there is a preservative, which is also a pesticide known as chromated copper arsenic, CCA. It's used to pressure treat wood, and it's found in decks and playground equipment everywhere, and I mean everywhere. With age, this pesticide leaches into the dirt, which is what happened in my client's yard where their children played every day.
But why should the EPA be held liable? They didn't make that playground equipment.
Our argument is that the EPA knew about the dangers of this pesticide. They've known about it for almost 30 years, and yet they have continued to let the wood preservers use this stuff.
This is a complete lie.
Would you shut up?
Counsel?
He's arguing the merits.
Let me deal with him. The basis of your claim is that the EPA knew of these dangers.
Our claim is that when a governmental agency knows of a toxic condition that causes developmental problems in the nervous system of children, when a governmental agency knows of a toxic chemical that is being regularly used to make playground equipment, when that governmental agency does nothing to stop it, then yes, that agency is blameworthy, and yes, that agency should incur some liability.
Ms. Frutt, first, I can do without the tone. Second, we could complain every day about the government not doing enough. We can't prevent every disaster, you know that.
Yes, but this disaster was preventable.
As are most automobile casualties, too. The government could mandate that every car be built like a tank. They could legislate that every airline passenger be equipped with a parachute. There are lots of things the government could do to make things safer. But there are economic realities.
I understand that. And if the economics of fixing a problem is prohibitive, fine. But how about simply informing the public that a problem exists? They know there is a chemical that causes harm. How about simply alerting the public? Would that be too much of a burden on the federal government?
Maybe not. My question is, do they have a duty to?
Our position is that they have a duty to make known all toxic, dangerous conditions that they know of. The EPA is still sitting on this information. That chemical is still leaching into the dirt at playgrounds. Children are playing in that dirt, and the EPA still isn't informing people. Why? Because the wood manufacturers have lobbied Congress to get the EPA to back off. And the only reason why I know about this problem is because of 3 sick children whose parents hired me.
Closing?
Yeah.
If a client wants to testify, it's his right.
He's not seeing straight. The guy is talking about Fiji.
He's competent. He wanted to testify, and you prevented it.
And what would the result be of that videotape?
He's competent. His decision was to testify.
And you sat silent.
So we're both guilty.
He lied, Richard.
We don't know that.
Of course we do.
Helen.
Oh, come on. The stuff about his sister being afraid or call the police.
We don't know that it's untrue.
I know what you said to him, how you coached him to be...
Hey, Helen.
The man committed perjury, Richard. We both know it. That testimony could convict.
Even if he did perjure himself, all we have is suspicion.
Yes, we're both technically covered. That doesn't solve it. We could have an innocent man here who could end up serving a life sentence based on lies which we put into evidence.
First of all, he's not innocent.
I think he is.
Your opinion isn't relevant. Second, there's nothing we can do about it now. The witness said what he said. For all we know, it could be true. So we just do our job and argue the case, period. Oh, and I suppose you'll never be able to live with yourself now.
Actually, I was thinking how I'd never be able to live with you.
If you can't bring yourself to close, just say the word.
The word here is the most damaging prosecution witness just concocted a bunch of big, fat lies. Now look, I can't prove it, but I know it, and so do you.
All rise. Be seated.
It seems strained that the government, by creating an agency to watchdog private industries, could thereby become liable for the conduct of those industries. I am further troubled by the reality that it's the taxpayers who pay these judgments, should there be any. True, the Environmental Protection Agency is mandated to regulate pesticides. But to say that the EPA knew of a leaching problem and failed either to correct it or to warn about it makes them negligent to the point where they should assume responsibility is a hard leap for me to make as a juror. But it is, in fact, a question a jury should be deciding, not a judge. Defense motion for summary judgment is denied. Trial date is set for next Tuesday. Adjourned. What happened?
We won the motion. That's what happened. We're still alive.
I don't believe it. I mean, I do, but I don't. Okay, we've got a lot of work to do on our damage claim, and the trial is set for next week, so we've got to get together tonight.
7 o'clock in our office.
Miss Rutt, can we talk? No. You have anything else to say? You say it to a jury.
Mr. Jameson, nobody wants a long trial here.
After 8 months? That's what you say to me? Go to hell. Take your friend.
They have no case. They find my client's prints on the garden hose. Yes, because he yanked it out of the car. They find his prints and DNA on the victim. Yes, because he tried to revive her. There was a fracture on the back of her head. Yes, because Scott Wallace pulled her out of the car, causing her head to hit the cement floor. And seeing how anemic the case is against Scott Wallace, the man he believed killed his sister, Kyle Barrett took the stand and lied. He testified his sister was afraid Scott would harm her. Well, Kyle Barrett never told the police that, never. He just made it up. It was a desperate lie that cannot be corroborated by anyone. And it's with that lie alone that the prosecution is trying to convict an innocent man. My sister was afraid he'd harm her. If I disappear, Scott did something. And he goes off to play poker? The reason Kyle Barrett made up these lies is because sitting in this room, listening to the evidence, he recognized what you have to recognize. The prosecution has no case.
A woman announces to her husband that she's going to leave him. They're heard in a screaming argument, and she suddenly turns up dead. We're supposed to think suicide? Is there anybody who knew her to describe her as suicidal, or even depressed for that matter? Does it make sense? As she decides to move forward with life, she then decides to end it? As for the brother's testimony being a lie, where's the evidence of that? Did defense call anybody to contradict him? Let's all use a little common sense, shall we? A woman tries to leave her husband. She ends up dead in the house. A whack to the back of the head. No witnesses. Figure it out.
Every day, they need to be there.
Yes. Our case is your children, and we want the jury to see their faces every single day, even during the doctor's testimony.
They can do it. We certainly prepared them.
The defendants have already brought a motion to bifurcate the trial, which we are opposing, which means we really should get to work. So we will be in constant contact as we draw closer.
Okay. Miss Frett, I apologize for what I said before.
You don't have to.
Yes, I do. I know how hard both of you have worked. And as I watched you in the court, well, I felt ashamed for doubting you. That was something.
Thank you.
Will the defendant please rise? Mr. Foreman, the jury has reached a unanimous verdict.
We have, Your Honor.
What say you?
Commonwealth versus Scott Wallace on the charge of murder in the first degree. We find the defendant, Scott Wallace, guilty.
Members of the jury, this completes your service. You are dismissed with the thanks of the court.
Defense moves to set aside the verdict or for a new trial.
You can file those motions later. Security will take the defendant into custody. We're adjourned.
We've got some grounds. The ruling to allow your statement weak. We've got some grounds. We'll appeal.
Where are they taking me?
They're transferring you to Cedars.
We have grounds, Scott. We'll appeal. Okay. Appeal. Okay.
Would you have a comment?
Will you appeal? Yes, we will appeal.
You stinker!
Previously on the practice.
My client was in shock at the time of this interrogation. He had just found his wife dead less than an hour before this.
I'll allow the videotape for impeachment purposes only.
He killed my sister. Don't tell me now that he's going to walk.
Mr. Barrett, we had hoped to be able to introduce the videotape interrogation.
And you can't?
Not unless we get him on the stand. This will only happen if his lawyers think he's losing.
Which means when we ask you, did your sister seem suicidal? A response of, I didn't think so, isn't gonna do it. She was murdered, if you know it. She did not commit suicide. You absolutely know it.
Did your sister say anything else, sir?
She said that if she turned up missing, that I should call the police, because Scott probably did something to her.
Objection!
I know what you said to him, how you coached him to be...
Hey, Helen.
The man committed perjury, Richard. We both know it.
I want to testify.
I can't let you.
Poppy.
The defense rests, Your Honor.
We find the defendant, Scott Wallace, guilty.
This thing was built to bring children joy, and it's toxic.
The number Eleanor and I think is reasonable is $160 per child.
Nothing is good enough for what they did to our kids.
$20,000.
20,000?
Apiece.
And we're only offering it to avoid the publicity that this hearing might generate.
We have children with severe learning disabilities.
Even if that thing is toxic, the government didn't manufacture it.
I don't think we'll lose at summary judgment.
To say that the EPA knew of a leaching problem and failed either to correct it or to warn about it makes them negligent is in fact a question a jury should be deciding, not a judge.
What happened?
We're still alive.
Are your experts ready?
They're all set.
Dr. Tillotson flew in this morning. He's going to be great. He's very dignified and very persuasive.
Who have they got?
The EPA? How about everybody? They can't afford to lose this case. The precedent would be a disaster.
She's nervous.
I am not.
Okay, look, this is not like tobacco, where the jury's going to go in thinking that the defendant is evil. There's no predisposition weighing in your favor here. In fact, in this case, the jury's fears will work against you.
How do you figure that?
People don't want to believe that playground equipment all over is poisoning their children. They don't want to believe that the government could know about it and just look the other way because of politics.
Well, that's exactly...
People don't want to believe it, Eleanor. And you have to be mindful of that as you try this case. You are arguing something nobody wants to accept.
Okay, Bobby, we get it.
How is your science?
It's circumstantial, but credible.
Don't focus on proof so much. It's hammering the fact that the EPA didn't test this stuff enough.
All right, Bobby, we have done this before. We've been preparing this case for 8 months now, and we know what we have to do. Anything else?
Yeah. Win.
You ready?
Yeah, as ready as I'm gonna get. Aren't you going in today?
Yeah, just moving slow.
You okay, Helen?
Yeah. Don't I look fabulous?
It's just you've been acting a little blue for about a week now.
Really? Must be a midlife thing. Promised myself if I wasn't rich and famous by 30, I'd at least be sleeping with someone who was.
I'm working as fast as I can, Bobby.
Get Jimmy to help you.
He's third chairing the Jamison trial.
Look, while we sit on our hands, Scott Wallace is sitting in jail.
Nobody is sitting on their hands, especially me.
I'm off to see him now.
Bobby, you are going to let him in on everything he has to appeal.
The injuries are neurological, most likely caused by a toxin.
Did you form an opinion, doctor, as to what caused these neurological injuries?
We couldn't make any findings to a medical certainty, but it's my belief that these children were exposed to arsenic poisoning, and it was determined the likely culprit was a play gym in the backyard.
Okay, and can you tell us why you fault the play gym?
The wood was treated with chromated copper arsenicals, commonly known as CCA. It's a fungicide. It's an insecticide. It's also a carcinogen. Over time, it can break down. The kids touch it. They put their hands in their mouths and they ingest it. The neuropathy these children suffered is consistent with the injuries typically caused by exposure to CCA.
You can't prove that this play equipment caused these problems, can you, Doctor?
Can I prove it? No.
In fact, Doctor, you can't even prove to a medical certainty that exposure to CCA even causes neurological damage of any kind, can you?
There is certainly enough anecdotal evidence to strongly suggest that it does.
Can you prove it, Doctor?
One of the reasons it hasn't been scientifically proven is that we haven't done enough testing.
You cannot prove it. Can you, Doctor?
No.
Miss Gamble?
Mr. Barrett, thank you for coming by.
What's going on?
Well, nothing to worry about, but, you know, I'm anticipating the defense to appeal. I think I told you this.
And?
My feeling is one of the grounds they'll be raising is the veracity of your testimony. I thought I could best head that off at the pass by offering polygraph results. You could take the test in my office, won't take more than an hour.
I thought they were never admissible.
For suspects, for witnesses, they can actually carry some weight.
I don't want to take any polygraph.
It would be a big help to me if you did.
I'm sorry, I don't want to do that.
Why is that, Mr. Barrett? Did you not tell the truth? I'm gonna need that polygraph. Otherwise, I might be compelled to go to the judge and ask for a new trial.
I don't know what's going on, Miss Gamble, but I'm not taking a lie detector.
You could be facing perjury, Mr. Barrett. I think you should have your lawyer pay me a visit. Today.
All these names came out of your wife's Rolodex. I need you to go through it and tell us who they are.
What are you looking for?
The desperation of it will probably depress you.
Well, tell me.
Well, is there any possibility that it wasn't suicide? That somebody else killed her?
What?
I know it's out there, but, well, she was leaving you. Suppose she was seeing somebody else. Suppose after you two fought, she called him and he came over to get her.
And killed her?
I haven't exactly thought it through. I'm just groping for something.
No, you're right. This depresses me.
Just go through the list. I want to know who everybody is.
What about the appeal?
We're putting it together. Listen, Scott, you have one of the grounds we need to talk about. It could cost me my bar card.
What are you talking about?
You were denied your right to testify by me. You were adamant about getting up there, and I just cut you off and rested the defense. I think it's an issue.
Well, you did it because you believed it was the best strategy.
But in the end, it has to be your decision, and I totally usurped it. You might want to think about hiring a new lawyer and making that one of the grounds for appeal.
What, can't you argue it?
It's a little strange for me to argue my own infraction.
Bobby. In the situation that I'm in, it's not likely I'm going to get out of here. I know the odds. Now, if I am to have any chance, I need a lawyer who feels he's in the hole here with me. And you're it.
Now, doctor, can you get the arsenic on your skin by touching the playground equipment?
When the coating breaks down, absolutely. It can even be inhaled, especially when the wood is wet.
Have any studies ever proved this?
Yes. And the EPA evaluated studies in 1978 and further studies in 1981 and 1987.
All right, doctor. Is this wood a real risk in your medical opinion?
Everybody defines risk for themselves. But let me put it this way. These things are cancer death traps, and they're in backyards all over the country.
Those EPA tests about inhaling and ingesting the arsenic off wood, those studies were on unsealed wood, weren't they, Doctor?
I believe so.
Well, the wood on this playground equipment was coated.
In time, the coating breaks down, and seepage from arsenic increases.
What about the wood we use to build our houses? That's all treated with a termite pesticide, isn't it?
Yes.
Carcinogen?
Probably.
So maybe even our houses are potential cancer death traps, right, Doctor?
We can't rule it out.
The house you live in, what's it made of?
Wood. But being inside, the coating is less likely to break down.
But the outside wood on our houses, our porches, our decks, this is all treated with CCA, same as the play gym equipment, right, Doctor?
Most of it is, yes.
So basically, we're all living in death traps. according to your medical opinion?
We can't rule it out.
Overall, I think he came off well, and it was a good first day. We still obviously have big problems on causation, but I think the jury's with us.
They definitely are. I was watching their faces.
What happens next?
They'll put up Feldman from the EPA. Lindsay, you ready?
Totally.
This guy is tough. He's got experience as a witness, and he's not afraid to go right back at the lawyer.
I'm ready.
If we do damage here, our chances become very good.
Do we testify?
We've decided to hold you for rebuttal. We want your testimony to come as close to the end as possible. Our goal is for the jury to be thinking of a family in that room, not just chemicals and a bunch of scientists.
But your feeling is it's going well so far?
I think it's going quite well. But their big gun comes next.
You okay?
Yeah. Yeah. Just thinking.
You cross on the doctor?
I've got to get him, Bobby. If I don't get him...
You will. You will.
First of all, whether a district attorney thinks a witness lied or not, that has no relevance.
It does to me.
It's the prerogative of the jury to weigh his credibility. They did so.
Mr. Stone, your client lied. A man is serving a life sentence in part because of that lie. Allow me to be a little bit uncomfortable with that.
Okay, Miss Gamble. I'll put myself in your shoes and feel your discomfort. Now you put yourself in mine. Why in God's name would I ever agree to let Kyle Barrett take a lie detector?
How about simple justice?
I was away last week. Did the system suddenly become about that?
I don't find cynicism persuasive.
Well, idealism can be pretty incredible as well. I will not let my client expose himself to possible perjury charges.
I will grant him immunity on that.
Nor will I advise him to help undo the conviction of his sister's killer.
Mr. Stone, I won't sit quiet on this.
Please. What are you going to do?
The Environmental Protection Agency did extensive testing on CCA throughout the 80s. We continue to test it, and we have consistently found that it does not pose an unreasonable risk to either children or adults.
But with the possibility of a risk, shouldn't the EPA do something?
We have. The EPA developed a warning program which requires retailers to issue advisories that CCA poses potential hazards. Their contention that we have done nothing here is false.
Well, I think their main contention is you haven't done enough.
We have federal insecticide laws to deal with. Under the law, we have to weigh the potential adverse effects of a chemical against the economic and social benefits and costs. With CCA, wood lasts up to 5 times longer. Now, this represents a huge benefit to schools who could never afford playgrounds otherwise, to poor communities who could never build them without the preservative.
But with the chance they cause cancer, do we want schools building them?
Well, if it really caused cancer, of course not. But to date, there is no conclusive evidence that exposure to CCA causes cancer or any neurological side effects. There just isn't.
Are there any conclusive studies to show that it's safe?
No, nor are there with most food preservatives. Should the FDA ban potato chips?
Potato chips don't contain a pesticide.
The pesticide is coated. It is sealed, counsel.
What if the seal doesn't work? You're aware of Dr. Stillwell's study showing the arsenic is leaching from this playground equipment into the soil?
That's one study. The EPA has asked to see the data supporting it. Until we review it, we can't attach any scientific credibility.
The state of California does. They ban these wooden play gyms from schools unless they're recoated every other year out of fear that the children could be poisoned.
Many scientists feel that that was an overreaction.
In 1997, a group of physicians and scientists informed the EPA that wood preservatives constituted a health threat to this country and...
Yes, and conservationists lobby us on behalf of the rainforest. But without these preservatives, more trees would be cut down.
So kill a child, save a tree?
Objection.
Sustained.
You talked about the EPA requiring advisories, warning that CCA poses a potential health risk.
Yes.
Actually, that was a voluntary program, wasn't it, Dr. Feldman? If the wood industry didn't want to issue the advisories, they didn't have to, and most of them still don't, right, Doctor?
This wasn't a situation where a mandate was warranted.
The truth is, you were all set to issue a mandate here when the wood manufacturers suddenly lobbied Congress to get you to back off.
I don't know anything about that.
And isn't it true the EPA also backed off, requiring further studies, when the chemical industry gave $4 million in campaign contributions to congressmen to lean on you?
The EPA has never been bought, Counsel, I assure you.
I show you the EPA's 1981 position paper regarding inorganic arsenicals, and I ask you to read the highlighted paragraph.
All this basically says is, we don't know.
You don't know. That same paper cites a 1973 study which associates arsenic-tainted milk with severe retardation, lower IQs, and abnormal EEG findings.
That was a study of Japanese babies.
You don't count Japan? What else doesn't the EPA know, Doctor, and when did they not know it?
Objection.
Withdrawn. In 1996, the EPA failed to warn over 1 million power plant employees that they were at risk for mercury poisoning.
Objection.
Because the coal lobby pressured you, backed off there.
Objection. Relevance.
Goes to pattern. They were bought then just like they're being bought now.
Objection.
Overruled.
You lay off chemical companies, don't you, Dr. Feldman?
That is absolutely not true.
From 1989 to 1998, of all the hundreds, if not thousands, of pesticides out there, how many did you get neurotoxicity data on?
I don't know the exact number.
I do. It's 9. Of the hundreds, if not thousands, of industrial chemicals, how many did you ask for and get the neurotoxicity data on?
Again, I don't know the number.
It's 3. You guys are quite the watchdogs.
Objection.
Withdrawn. Nothing further.
Of the 5 names you couldn't identify, 2 were maiden names of married women you did ID. 1 was a pool contractor.
Oh, yeah, we were thinking about installing a pool last year.
1 we're still checking. 1 was a psychiatrist, Dr. Bernard White.
Psychiatrist?
Was your wife seeing a shrink?
Not that I'm aware of.
He's in Cambridge. I'll pay him a visit. Listen, on the other, I understand if you want to replace me. I'd even recommend it.
Can you recommend someone as good who will try as hard? Look, Bobby, I'm glad you think you screwed up. It's my insurance policy that you'll keep trying.
I'll keep trying. You don't have to worry about that.
I'm not.
They told us it really wasn't that uncommon for a boy to have seizures.
Did they test him for epilepsy?
Oh, they tested him for everything. They finally settled on a toxin getting to the brain.
And what did you do?
There was nothing we could do. We got him on medication, which controlled the seizures. We thought, you know, that was that. Then, Sarah started falling down.
What do you mean she started falling down?
She would trip. If she tried to play hopscotch, she'd fall flat on her face. They thought maybe she had cerebral palsy.
And then things started to happen with Everett?
He can't read. He will never be in a normal class. He'll never go to college. And you knew.
Objection.
I have a boy whose body convulses with foam coming out of his mouth, and a daughter who keeps falling down, and a son who can't read, and you people have known for 30 years.
Your Honor.
Mrs. Jameson, please just answer the questions you're asked.
What was the question?
The question was, when your son started having seizures, didn't the doctor say it could have come from a whole host of chemicals, including the cleaning solutions you kept in the house?
And then I got rid of all that stuff.
Do you live near high-power lines?
Yes,
And did the doctors inquire about them?
yes, they ruled them out as a cause.
Did you and your husband undergo any genetic testing?
No,
I see. Where is the play equipment today?
it's still in our backyard.
You think this equipment is harming your children and it's still there?
We don't let them play on it.
Well, why not get rid of it altogether?
Our lawyers told us not to, not until we
Objection. I need to advise my client that that is privileged. She does not need to answer that. It's also work product.
You kept it as evidence for your lawsuit?
Objection.
Sustained.
Just one last question, Mrs. Jameson. Did any doctor who treated your children conclude that their problems came from the CCA and the play equipment? Did any of them conclude that?
No.
Thank you, Mrs. Jameson.
We really appreciate you taking the time.
Sure. But as I told you on the phone, I'm not comfortable revealing information about my patients.
I understand. You did treat Mrs. Wallace, then?
I know the identity of my patients aren't protected by privilege, Mr. Donald. Nevertheless, I am reluctant to reveal them.
But as you said yourself, that isn't privileged, and even if it were, it wouldn't survive the death of the patient.
Mr. Donald, I know what the law is. I know you can subpoena my records. Hence, I agreed to this meeting.
Could you tell us what you were treating her for?
Anxiety, sleeplessness, and depression.
Did you say depression?
Yes.
You know that we argued that she killed herself.
Yes, I read the papers.
Why didn't you come forward? The prosecution was claiming she wasn't suicidal. You had information that she was depressed.
Mr. Donald, 80% of my patients are depressed. They don't typically take their own lives.
But sometimes they do.
How could you sit on this?
I sat on this because I don't believe that Karen was suicidal. Secondly, if psychiatrists start speaking posthumously on their patients, that could have a chilling effect on treatment. Most people want their records sealed before their death and after.
We had a man charged with murder here. The jury convicted him because they didn't believe the idea she was depressed.
Don't yell at me.
I will yell at you!
Bobby.
What the hell were you thinking?
All right.
I was thinking she was probably murdered.
Well, you were wrong!
Bobby. We need this guy. Can we get those records? Please.
We live in a land of chemicals, and it's pretty out of control. There's an epidemic of autism in California. It's up over 200% in the last 13 years. In New York, learning disabilities are up 55%. The likely culprit? Chemicals. And we can't expect the private industries to monitor themselves. The market is just too competitive, just like in everything else. If the wood manufacturers can make these play gyms and deck porches better, more profitable, they will. And they won't worry about the toxic side effects. And that's why we need the EPA. Just like as the airlines become more competitive and cut back on their mechanics to increase profits, we need the FAA to step in and protect us. So too do we need the EPA to fulfill its duty to the public. And the fact is, they're not. They've known for decades it could be dangerous. And they have done nothing. They are still doing nothing. Why? in part because of politics. Campaign contributions from chemical companies and wood manufacturers have resulted in successful lobbying to get the EPA to back off. And children, like the Jameson kids, are getting severely hurt. The EPA throws its hands up and says, hey, you can't prove it. We don't know for sure. We don't have the data. Tests are incomplete. Well, why aren't they ordering those tests? Why aren't they demanding data? They've restricted the use of CCA around farm animals, but not around children. Is it because the farming industry has a lobby, but children don't? What is going on? They've known for decades that there's arsenic in that wood. It gets out, it gets ingested, it gets inhaled, and they haven't done so much as to alert the public of the risk. And that's all it would have taken here. A simple warning. And the Jamesons never would have put that play gym in their backyard. You heard their star witness, Dr. Feldman. He said EPA decisions are made on a cost-benefit analysis. We need you to put a big price tag on their failures. We need you to make it cost-efficient for them to protect our children. One thing is clear. If you don't, they won't.
She's right about one thing. We do live in an age of chemicals. Want to kill the mosquito with the Nile virus? Chemicals. Don't want to get botulism from your canned soup? Chemicals, preservatives. And I suppose the EPA could demand proof that every one of those chemicals is completely safe before allowing their usage. And people would die of contaminants and viruses and bacteria. Many, many more people. Almost every consumer product poses some unproven health risk. Should the EPA ban them all? They studied CCA in wood. The EPA appointed a special scientific advisory panel to look at this. Their recommendation back to the EPA was not to ban the substance. Now, the plaintiffs may not like those scientific findings. They may choose to disagree, but this notion that the EPA knew it was dangerous and chose to ignore the risks under the influence of paid-off congressmen, that's as slanderous as it is baseless. This is something they are studying. The EPA is a government agency doing its very best to keep up with this rapidly changing scientific landscape. And the decisions it makes, they have to be made on what is known, as opposed to what's not. And today, like yesterday, it has not been scientifically established that CCA causes the neurological defects the plaintiffs speak of. And even if it did, they have offered no medical evidence whatsoever that it did so in the case of the Jameson children. Their own doctor admitted she was speculating, she was guessing at what caused these injuries. As much as you may feel for these children, and you should feel, as should we all, we have to admit that their entire case is based on pure speculation and nothing more.
You want me to sign this?
It's what happened, Richard.
An affidavit saying I coached a witness to lie?
It doesn't say lie.
That's the implication.
Richard.
What the hell's going on?
We both know he lied. He made that stuff up about his sister being afraid.
Helen, what are you trying to accomplish?
He should get a new trial.
I'm not signing this.
Richard, we
You're
can't
not
just
taking me down. You might have some professional death wish. I don't. And if you think that I'm going to let you go forward...
I was in the room. I heard what you told him.
I told him what his testimony needed to accomplish. I never said lie.
But that is what he did.
You don't know that. Maybe he lied, but neither of us know that.
Maybe you can live with this conviction. I can't.
Well, I'll fight you on this, Helen. I'll fight you all the way.
You know, Richard, it's one thing to be competitive. It is another to try and rack up convictions out of ambition with no regard for a man's innocence.
I don't believe he's innocent. And if you go forward saying, I coached a witness to lie, your career could be over. Our friendship definitely will be.
I don't know if the jury liked your closing, Lindsay, but the defense was impressed. We have a new offer.
What?
$225,000 per child. That's $675, and they will write a check right now.
That beats 20,000.
It certainly does.
Should we take it?
Well, it's hard to turn that down. But I suspect they had jury consultants sitting in on the trial who had advised them to settle, so I don't know. $675.
Could we get more?
We could. We could also lose.
I think we're gonna get more.
Why?
I just do.
This isn't the time to get greedy.
It's not about greed, Mr. Berluti. Like Lindsay said, we want them to fix the problem.
Angela has intuition about these things. Let's go to verdict.
Are you sure?
Are you?
It's going to be more.
It's right here, depression. He wanted to prescribe antidepressants, she didn't want to take them. It's all right here.
Lucy, see if we can get in to see Judge Wolf this afternoon. This is new evidence. Eugene, call Helen Gamble. Tell her. Helen, we were just talking about you. We got new evidence on the Wallace case.
Really? I've got some news on that myself.
What?
I'm convinced that Kyle Barrett lied on the stand after being coached by the prosecution.
Is it a good sign them coming back so fast?
No. Deliberations on damages would have been lengthy. If they find no liability, then damages will be moot.
Can we still take their offer?
I asked. They laughed.
Madam Foreperson, the jury has rendered its verdict.
We have, Your Honor.
What say you?
In the matter of Stephen Jameson et al. Versus the Environmental Protection Agency, we find in favor of the plaintiff and order the defendant to pay damages in the amount of $72 million.
Oh, my God. Oh, my God. Oh, my God.
Your Honor?
All right, settle down. This court is still in session.
Your Honor, the defense moves to remit the award. We also move that the verdict be set aside.
Opposed.
I will see counsel in chambers immediately.
What's going on?
They're looking to strike the award as excessive.
Can they do that?
Well, $72 million is a lot.
But that's what the jury found.
Let us talk to the judge and we'll see what's going on, okay?
The
number alone tells you the jury was off base. The fact that they deliberated for an hour.
Maybe it has something to do with the merits.
All right. I'm granting defense's motion to remit. The knockdown number is 135 per child.
What?
You chopped it from 72 million to 400,000?
That's less than they offered.
I don't care. Your case was pure speculation, counsel.
This isn't a matter of law. You are substituting your judgment for theirs.
Which I'm entitled to do when the verdict isn't supported by the facts.
We have a right to a new trial. We do not have to eat your number.
If you take a new trial, you'll be right back before me, Ms. Frutt. And any number over 135, I'll remit again. If you're lucky to win next time, there's no guarantee the jury will be as stupid as this one. And if you do win, I might remit the next knockdown to 75,000. I strongly suggest that you accept this proposal.
This isn't right. This isn't right.
Meet with your clients. Then notify my clerk of your acceptance.
Given this newly discovered evidence concerning the victim's depression, coupled with this revelation by the district attorney regarding the veracity of their lead witness, the interests of justice demand that the verdict be overturned. In the alternative, the court should order a new trial.
I take strong exception to the suggestion that I coached a witness to lie. There's no evidence the witness did lie, only opinion.
Coming from Helen Gamble.
Helen Gamble's opinion carries no legal relevance. I assure you she has no credibility within our own department.
Why? Because she's honest?
All right.
Your Honor, this was not our lead witness. This was a witness.
Who supplied motive?
You challenged his truthfulness at trial. You have nothing new with which to challenge it here. As for the doctor's report, I spoke to Dr. White. He did not consider Karen Wallace to be suicidal.
The prosecution portrayed her as optimistic.
Which you also challenged at trial.
Not with these medical reports, we didn't.
All right. Ms. Gamble brought her concerns regarding this witness to the court's attention. As I told her, it is the jury's function to weigh Mr. Barrett's credibility, not hers. As I go through her affidavit, I don't think Mr. Bay crossed the line. Lawyers prepare witnesses all the time. I see no evidence that he solicited perjury. As for the doctor's report, I find that to be relevant. But I am not satisfied that it would have resulted in a different verdict. The conviction, therefore, stands. Defendant's motion for a new trial is denied, and we are adjourned.
I'm not quitting.
Well, what happens now?
We go to appeals, challenge some of the legal rulings. I'm not quitting.
I don't understand.
The judge can cut back an award if he thinks it's too high.
What's the point of a jury trial? We go through all that with a jury.
Well, judges don't like to do it. With this guy, I'm not sure.
So if we opt for a new trial, we'll get him again?
That's what he's saying, that he's going to keep it on his docket. It could be a year before... I'm going to be sick.
I think we have to eat it at 135. If he keeps jurisdiction, he's told us that we can't do better. We could lose.
This is so unfair.
We should be able to get the money today.
We got no choice.
This isn't fair.
You blindsided the department, embarrassed it. And now we have to deal with a media that... I think it would be best if you submitted your resignation.
You're not getting my resignation. And if you fire me over this, then just watch the media come at you.
Why are you doing this, Helen?
We all say better to let a guilty man go free than put an innocent one in jail. An innocent man is serving a life sentence, Kate. If this were Texas, he might already be dead.
When suddenly did you become the jury?
The jury doesn't know he passed a polygraph. The jury doesn't know a witness was coached, that he lied. Jury doesn't know a lot of stuff, Kate. I do.
You're right, Helen. I can't retaliate over this. So I'm gonna just go back to my office and wait for your next mistake. Every day, I'll just wait.
Thanks for dropping by, Kate.
Okay, look. We had a bad day. We'll have them again. We can't just sit here and brood.
Beck's right. We gotta concentrate on picking up pieces now.
I'm gonna get him. That judge, I'm gonna get him.
You stinker!
Previously on the practice.
When we ask you, did your sister seem suicidal? A response of, I didn't think so, isn't gonna do it. She was murdered. If you know it. She did not commit suicide. You absolutely know it.
She said that if she turned up missing, that I should call the police, because Scott probably did something to her.
Objection!
You want me to sign this? An affidavit saying I coached a witness to lie?
He made that stuff up about his sister being afraid.
Helen, I told him what his testimony needed to accomplish. I never said lie.
I'm convinced that Kyle Barrett lied on the stand after being coached by the prosecution.
I don't think Mr. Bay crossed the line. I see no evidence that he solicited perjury. The conviction, therefore, stands.
This thing was built to bring children joy, and it's toxic.
We have consistently found that it does not pose an unreasonable risk to either children or adults.
I have a boy whose body convulses, and a daughter who keeps falling down, and a son who can't read, and you people have known for 30 years.
We find in favor of the plaintiff and order the defendant to pay damages in the amount of $72 million.
I'm granting defense's motion to remit. The knockdown number is 135 per child.
That's less than they offered.
I don't care. Your case was pure speculation, counsel.
We have a right to a new trial.
If you take a new trial, you'll be right back before me, Ms. Frutt. And if you do win, I might remit the next knockdown to $75,000.
I'm gonna get him. That judge, I'm gonna get him.
$60. That's something.
You don't have to do
No,
that.
take it. You pay me back when you get it. Listen, Jennifer, you're a smart girl, a good girl. I can judge character. Don't be doing this.
Thank you.
Go. Wipe that stuff off your face.
I will pay you back.
Yeah. Well, in the meantime, get a paper route or something. Don't be doing this.
Jimmy,
You're having a kid? You didn't tell me that.
I didn't want you to get mad.
How could you still be doing drugs?
It was just this one time. Billy left me. He left me like this.
What about rehab?
I called that number that you gave me, but they said that I couldn't interview for 2 weeks. And then I lost the number.
How far along are you?
8 months. Can't you get me out? Jimmy.
You were smoking crack with an 8-month baby.
It was just once, I swear.
No, it wasn't.
Jimmy, I'll do the rehab. I'll do anything that you want me to do. Please just get me out.
If I get you out, and I'm not saying I can, but if I do, you go into rehab immediately, straight from the courthouse.
I promise.
Tell me about the arrest.
Okay, everyone, let's get started.
Somebody make it official that you're in charge?
Brain's beauty and character. Don't knock it.
Okay, let's go. Jimmy.
Jennifer Cole, possession of crack cocaine.
Again?
I got a motion to kick at 9. She's 8 months pregnant.
What? And she's smoking crack?
Believe me, I tore into her already.
She better hope her baby doesn't die. She could be charged with murder. Did you tell her that?
I'm not positive I did, but I will. Thank you, Lindsay.
She should be shot.
All right. Beck, how's the research coming?
Okay.
Can you give me something a little more than okay? I'm seeing Scott Wallace later.
Sure. We can argue reversible error when Judge Wolf didn't have an evidentiary hearing on whether Richard Bay suborned perjury. Now, since we have Helen Gamble with us, I think that's our best shot.
What else?
Well, the neighbor's testimony that he heard lots of fights between Scott Wallace and his wife, prior bad conduct, inadmissible. We can argue reversible error there, too.
All right. Lucy, keep dogging the clerk's office. Eleanor, jump in with Rebecca on the brief.
I can't, actually. I'm a little jammed.
Not on my calendar, you're not.
I have an appointment with the chief judge of the district court today.
About what?
Judge Aldrich.
I didn't know.
I'm keeping you out of it.
Eleanor, we can't afford to be alienating...
It's one meeting. The appointment's made. I'm doing it. Aldrich was out of line. I'm not staying quiet. Forget it.
I was observing 4323 South Holden Green.
It's a known crack house. I witnessed Jennifer Cole exiting. She was stumbling and disoriented. Her appearance consistent with being under the influence of drugs.
What did you do?
I exited my vehicle, approached the suspect, identified myself as a police officer, and then engaged her in conversation. Her behavior confirmed my suspicion that she was high.
Could you describe that behavior?
She was sweating and jittery and was slurring her speech.
What did you do then, officer?
I conducted a quick pat-down search for weapons, and I could plainly feel an object in her jacket pocket. It was immediately apparent to me that the object was a rock of crack cocaine.
How did you know?
Well, I've received extensive training in recognizing crack. I felt a small object, asymmetrical, rough edges, a rock of crack.
Then what?
And I reached inside the defendant's jacket and removed approximately 100 milligrams of what was determined to be crack cocaine, wrapped in paper.
This rock of crack, how big was it?
About a half an inch in diameter.
So that's no bigger than what, an aspirin?
About that size.
And this tiny little thing was, as you put it, wrapped in paper?
That's correct.
In fact, it was inside a scrunched up brown paper bag, right?
Yes.
And the bag was inside a jacket, a big winter overcoat, in fact.
I don't recall exactly.
Officer, I'm showing you what's been admitted as People's 3. This the jacket Miss Cole was wearing?
Looks like it, yeah.
So, you do this one pat of Miss Cole's body, through this thick down overcoat and through a crumpled up paper bag. You feel this tiny little lump and you immediately know it's crack cocaine.
Yes.
No way it was jewelry, candy.
No.
All this from just one pat?
Yes. We received comprehensive and extensive training.
How many times have you used these comprehensive and extensive training techniques to frisk suspects for crack cocaine, officer?
Probably 10 times.
And how many arrests resulted from these comprehensively trained pat-downs, officer?
2 or 3.
So the other 8 people you frisked were innocent? Nothing further, Your Honor.
Ms. Alexander, the witness may step down. Does the Commonwealth have anything else?
No, but I would like to remind the court that in addition to pat-downs being constitutionally permissible, this woman is 8 months pregnant, and I would like to ask the court to seriously consider the consequences
The
of...
charges against Ms. Cole are dismissed without prejudice. You bring me some new evidence, you can refile. Ms. Cole, you're free to go.
I want to thank you, Your Honor, for being gracious enough to see me.
Well, there was nothing gracious about it. You somehow got my home number and woke me from a deep sleep. I had no idea what I was saying yes to.
We were basically blackmailed, Your Honor. Judge Aldrich told us to accept the knockdown number or else. And the or else being that he would order a new trial, keep the case, and steer us into defeat.
You're talking about one of my most respected colleagues.
Who committed gross abuse of discretion. What he did not respect you, Your Honor, or the court. It was blackmail, and I am not overstating it.
You can substantiate this?
Yes. My co-counsel Lindsay Dole was present, as was opposing counsel.
Ugh. If you thought the judge was out of bounds, you should have asked the court reporter to step in.
He never would have said that on the record.
But you need a record in order for me to act, Miss Frutt. At minimum, you should have appealed the reduction. Instead, you agreed to the knockdown and you took the money.
My clients took it under duress.
Well, that was a big mistake. And you made it. Maybe that's what's eating you.
What's eating me is being blackmailed by a judge. What he did was corrupt.
I don't see that on any appellate record.
What would be my options?
You could move for a new trial, request that Judge Aldrich recuse himself.
But Judge Aldrich would be the one who would rule on those motions.
Correct?
Is there another option?
You could file a motion with the Circuit Court of Appeals to have him removed for bias.
That's what I want to do.
It would be your word against his. And these judges would be Federal Circuit Court judges. Do you understand? He doesn't just get a jury of his peers here. He gets his friends.
That's what I want to do.
I'd think long and hard about that, Miss Rudd.
Well, now it sounds like you're threatening me.
No. I'm giving you some advice.
I want to file a formal complaint.
Richard, is this it? We're never talking again?
There's nothing really to talk about, Helen.
Would you at least give me 20 seconds? Look, I know this goes against your fiber, but sometimes the people we charge with crimes are innocent.
Scott Wallace is not innocent.
My point being, I think he is. I also believe a witness lied after you coached him. Richard, we're officers of the court. It has to mean something.
I understand that, Helen. I also understood you to be my friend. And you cut my legs out. You basically accused me in open court of being dishonest.
Taking it a little too personally.
Let me tell you something, Helen. I get called a lot of things. The defense attorneys call me the midget. The judges call me Little Napoleon. I take a lot of abuse. But I get through it every day because I also have a reputation for being good at what I do. And I have a reputation for being an honest person. That reputation is dear to me. And when a colleague, a friend, stands up and obliterates that reputation, it's personal.
Hey, Richard. Helen?
Jimmy.
Hey, I thought I could drive you to the hospital.
Hospital?
Rehab. I got you all set up. You can do it outpatient.
Well, I was gonna go see my aunt today.
You can see her after, Jennifer. You promised.
Okay.
What's up?
Mr. Belluti, please step aside. Jennifer Cole, you're under arrest.
What?
Arrest?
Please put your hands behind your back.
What the hell is going on, Susan?
Distribution of a controlled substance to a minor.
Distribution?
Distribution of what?
Don't say anything. What the hell are you talking about? Distributing to who?
The baby.
My baby?
You gotta be kidding.
You're smoking crack for 2 now.
What is she talking about? What are you doing? Jimmy!
You have the right
Jimmy!
to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you are being questioned.
Just calm down and hear me out.
I won't hear you out. This is so ridiculous. There's never been a case made for distributing to a fetus, and you know it.
Just because it's never been made before. She distributed cocaine to her baby through her bloodstream.
I'll be moving for sanctions on this, and I'll get them.
How sure are you she won't use again? Like tomorrow. She has a viable baby. If she hasn't done any damage yet, she might the next time. I'm just looking to get her off the street until the child is born.
I got her in rehab.
Yeah, voluntary outpatient. Come on.
You still can't arrest her.
Technically, I can make the case.
You're
Read the
deluding
statute,
yourself,
Jimmy.
There's no way
Delivering a
you
drug
can
to
win
a
this,
child,
Susan.
It could be blood to blood.
You can't win.
I can if you don't fight me.
You're asking me to conspire with you to keep her in jail?
1 month until the baby is born. I know you care for this woman.
I do, and I'm telling you, she'll go crazy inside. She needs help, not jail.
This is the only way she's gonna get help. If she walks, it'll be straight to the local crack house.
We don't know that.
Do you know what crack does to a baby? It cuts off the blood flow, oxygen, nutrients, seizures, heart attacks, brain damage. Let's plead this out. Inpatient rehab, no jail.
You're asking me to cop to a bogus charge.
I'm asking you to consider you really have 2 clients here.
Susan.
If she gets out, she'll OD, miscarry, who knows what'll happen. She trusts you, and you can help her.
It's a complete long shot. This is a very popular judge, and the other judges aren't likely to sanction him.
Well, what about the settlement that we agreed to?
Well, if we undo it, hopefully we can get you more. In defeat, you keep what you have.
So what happens?
Well, we have a hearing scheduled for tomorrow at 3:30. There's nothing to lose.
Okay.
You filed a formal motion against Aldrich.
What's the problem?
The problem, Eleanor, is this is not something attorneys do. Why? Because the federal court is like a club as far as judges go. They have tenure. They stick together. And the only thing that will come out of this is this firm will be retaliated against.
Oh, please, what can they do to us?
What can they do to us? You just saw firsthand what they can do. They could cut damage awards, overturn verdicts, give lousy instructions, deny bail, cut fees. What can't they do? Not to mention they could put all our cases at the bottom of the docket and we'd never even get to trial. What you're doing here could hurt all our clients. At a minimum, this should have been the subject of a partnership meeting.
Well, I've had bad experiences with partnership meetings.
Snide isn't what I was looking for.
Bobby, I have a plan, okay? I was hoping to avoid the hearing against Aldrich.
How?
I have a meeting scheduled with the lawyers for the EPA. I think with just a threat of the knockdown number being thrown out, I can ship the number up a little.
Somehow I don't believe this is about chipping up a number.
I am only trying to help the client. This is not about vengeance.
I don't understand.
You plead guilty to distribution. They'll recommend straight probation for a year.
Probation.
So long as you get residential treatment.
I hate those places, Jimmy. All those freaky junkies and weirdos. It'd be like poison for the baby.
You need help, Jennifer. You got an addiction.
I do not. I can stop whenever.
Then why haven't you? 8 months pregnant. Why the hell haven't you?
I'll go to my aunt's house. There's this little room. It's like the perfect size. I got no curtains yet because they're either going to be blue or pink, you know?
Jennifer.
Rehab's no place for a baby. A baby should be at home. Please, Jimmy, what do I do?
They got a case here, and they're real serious. I think you ought to take the plea. It's the best thing for you.
You really can't make it go away?
No.
How long?
We're hoping next week.
No, you gotta push it up, Bobby. I can't take this place. I mean, they see me as some rich guy. I mean, I'm gonna be meeting up with the end of a broomstick in here. Yeah, you gotta get me out.
Scott.
I mean, minimum security, something, work release.
Scott.
I mean, I got money. Milken got out with money. I can pay.
He was in on securities fraud. You're in for murder.
Look, get me out!
We're trying to push up the appeal as soon as possible, Scott.
I'll get a new trial, right? I mean, the judge made all of those mistakes. I gotta get a new trial. Give me a brand new trial.
That's what we're hoping for.
So you gotta hurry, Bobby. See, I thought I was okay, but I'm feeling maybe I'm not. Just hurry, okay?
Do you expect us to laugh?
No, I don't expect that, Mr. Myers. We have a hearing set up for tomorrow. These are your subpoenas to appear as witnesses. If you refuse...
And you think if you call us as witnesses, we'll testify that Judge Aldrich was guilty of blackmail?
I think if called as a witness, you will give truthful testimony, yes. And we all know what happened in that room.
Miss Frutt, I truly do admire your fortitude. But if you have any notion that we will compromise our client's interests...
You wouldn't be lawyers in this proceeding. You'd be witnesses.
You're insane.
Look, we're not really here trying to secure you as witnesses.
Why are you here?
If we're successful at overturning Judge Aldrich, that $72 million verdict could be reinstated. You have to be concerned about that.
We're not.
Do you really want to risk it?
The odds of that panel overturning Judge Aldrich's
Do you want to risk it? $72 million.
Why don't you get to the punchline?
For $6 million, we'll drop the complaint against Aldrich.
Once again, I must ask, do you expect us to laugh?
You won't be laughing if the 72 comes back.
I think we'll run that risk. Anything else?
The hearing is scheduled for tomorrow at 3:30. You've received your summons.
Yes, and between now and then, we'll be sure to go over our testimony.
You really are an ass. You know that?
Tell a friend.
He's extremely erratic. He's going on and on about buying his way out of jail.
Is he talking about Fiji again?
No, but
I just got off with the clerk from the appellate court. They can hear you next Tuesday.
scheduled. Can you have the brief ready?
Yeah, it'll be done.
What time's the hearing?
3:30.
I'm gonna go see Aldrich now.
What? Why?
I'm gonna try the velvet glove first.
You really think this guy's gonna listen to you after you file a motion against him?
Docket number 3542, Commonwealth versus Jennifer Cole.
Susan Alexander for the Commonwealth, Your Honor.
James Berluti for the defendant. Waive reading. We're entering a plea of guilty pursuant to an agreement.
Let's hear it.
1 year in the House of Corrections, suspended. 1 year probation, as long as she enters a detox center today. Upon release, she immediately goes to a halfway house, then to a sober facility for the term of her probation.
Just a second. This is the same offense as yesterday?
No, Your Honor, this has nothing to do with the search. The defendant was seen by witnesses ingesting cocaine.
The charge is distribution.
She is in her 8th month of pregnancy. She ingested cocaine, distributing the drug to her unborn child.
Come again?
The distribution was to her fetus.
What's going on? We're fine. Don't worry.
Mr. Berluti.
Yes, Your Honor.
You have fully explained to your client the nature of these charges?
Yes, Your Honor. Miss Cole understands the charges against her.
Do you? Ms. Cole, did Mr. Berluti explain that it's extremely unorthodox for a pregnant woman to be charged with this crime?
Sorry?
What did your lawyer say about the case against you?
I don't know. He said I should take the plea.
Did he say why?
Your Honor.
I am addressing the defendant. Did he say why you should take the plea?
He said we probably wouldn't win this.
Mr. Berluti, Ms. Alexander, Chambers. I have never seen this law enforced against pregnant women.
That doesn't mean it can't be.
I'm not sure you're right about that. But even if you are, I see no basis for a defense attorney to surrender. What did you two do? Decide on a punishment? Then flip through the general laws in search of a crime?
I don't believe you have the right to change a plea agreement.
I certainly have the right to reject one.
On what grounds?
Due process, unethical behavior, lack of legal basis, collusion. Take your pick. What's our role today, Mr. Berluti? Lawyer or mother?
I advised my client. The fact that you may disagree with my advice does not make me unethical.
You took an oath to zealously represent your client's legal interests, counsel. Getting her into rehab doesn't qualify. Did you inform her that this case would likely not make?
I told her I couldn't be sure.
Mr. Berluti, you might as well answer my question, because next I will be asking her. Did your client, when agreeing to this plea, fully appreciate that she would probably not be convicted of the crime with which she was charged?
My client is a crackhead. She can't even fully appreciate that she's killing her baby.
The plea is rejected. I'm reporting both of you to the state bar. Get out.
Ever see a cocaine baby, Your Honor?
Mr. Berluti, you are an officer of the court who is one word away from contempt.
We really don't want to go after you.
I'm touched by that.
Your Honor, we have great respect for both you and your position. But our feeling is you did cross a line here.
Let me tell you something, Miss Dole. I was at that trial every day. There was no case. You people should be laughing to get $400,000.
But that's an evaluation of the merits, which is the jury's function.
The jury blew it.
Okay. But to go from 72 million to 400, I mean, if I could prevail upon you to revise the knockdown number, I could certainly prevail upon the client to pull back on their complaint.
The client isn't pushing this. Eleanor Frutt is the driving force here. Don't you think I know that? Well, here's something she should know. I have life tenure. I will be here a long, long time with a vivid memory, and you people will not intimidate me.
We're not looking to do that.
Tell Miss Frutt I'm issuing a gag order in connection with this case. If she says one word to the press, she's in contempt. And if she snorts out a single negative utterance about me to anybody, I will refer her to the federal disciplinary panel for violating the court rules for disparaging a judge. If she wants a fight, she's got one. You go tell her that, Ms. Dole.
Richard, did you have the Wallace file removed from my office?
They're working on an appeal, Helen. Certainly you don't expect me handling it.
Why didn't you just ask for the file?
I couldn't presume your cooperation. For all I know, you might make copies of our work product and hand them to the defendant.
Look, I think you know in your head what I did wasn't personal, and what you're doing now is.
You act on your principles, Helen. I'll act on mine.
My principle was justice, Richard. Yours is politics.
Politics?
I know what's going on, Richard. I still have ears. Suddenly, I'm a pariah in the department, and you're choosing to distance yourself. That's fine. But let's not forget, your career was hanging by a thread a few months ago, and I'm the one who stood with you and behind you. Now, the idea that the association with me could be detrimental, you run. You're a hypocrite and a coward. Please do take that personally.
So you lied to me.
I didn't lie, but
I stand a good chance of getting this case dismissed.
yes,
You lied to me.
Jennifer. I'm just trying to keep you safe until the baby is born. You're still using, for God's sake.
So what happens now?
We go back in before Judge Spindle this afternoon. She might bond you over for trial. She might kick the case, depending on how convincing the DA is.
I want another lawyer.
If you want me to beat it, I'll try.
I want another lawyer. Can I get a public defender?
I'm sure you could,
Then
but...
that's what I want. You're fired, Jimmy. Please leave.
Jennifer.
You're fired.
You're gonna wind up dead or killing your baby. Guard.
And he said if we opted for a new trial, he would probably remit the next award to $75,000. He was clearly threatening to punish us if we exercised our legal rights.
Ms. Frutt, judges try to steer lawyers all the time.
This was much more than steering. It was a threat.
May I respond to that?
Please do.
If I was guilty of poor judgment, it was in allowing any award. For me, 75 was too high. But when you're sitting in front of sympathetic parents who've gone through the ordeal of a long trial in the wake of a jury verdict, I didn't want them to walk away empty-handed. That's why I gave them the 135. I let Ms. Frutt know she shouldn't bank on my continued sense of charity.
You chipped a $72 million award down to $400,000 out of a sense of charity?
I allowed you to keep the 400 on a claim that was really worth nothing.
We've certainly allowed murder charges to stand against people who caused the death of unborn viable fetuses.
But those are third parties, not the mother. Moreover, for drug distribution, you have to establish a specific intent, and there's been no showing of that.
Specific intent can be inferred.
Are you suggesting she intended to poison the fetus with cocaine?
All I'm suggesting is that if you commit an act that causes a result that is not only foreseeable, but in fact unavoidable, intent can be inferred.
I'm sorry, Ms. Alexander, but I have to consider the legislative intent. And there is no evidence that the drug distribution laws were ever meant to apply to pregnant mothers under this fact pattern.
There's no evidence to disprove the legislative.
Ambiguity cuts in favor of the defendant.
All I'm asking is that you bind her over. Let's just hold her
I can't do that.
In the alternative, I'd like to continue this matter. Allow me to do further research.
Denied. The charges against Ms. Cole are dismissed. This time I am doing so with prejudice. The defendant is free to go. We are adjourned.
Thanks. Thanks a lot.
Let's go.
Go where?
We have everything set up.
I'm not going anywhere with you, Jimmy.
Jennifer, you have a problem.
Whatever my problems are, I'm not about to come to you with them. Bye.
You people hardly have an unblemished track record, Miss Frutt. In fact, I might go so far as to say you have a penchant for deceit.
Whatever you may think of our penchants, we have always played by the rules. He didn't. It was cowboy justice.
I have to say, as I see the facts, most judges wouldn't have let this even go to trial.
Your Honor, we were in that room. We heard what he said and the tenor of how he said it. It was blackmail. He took away our Seventh Amendment right to a jury trial, and then he threatened us if we dared appeal. That's not the way it's supposed to work.
I know Judge Aldrich. I've known him for 20 years. I'd sooner take his word than that of a few criminal defense attorneys who moonlight with contingent fee cases.
I object to that.
Do you have anything else, counsel?
Yes, Your Honor. I'd like to call Mitchell Kravitz.
What are you doing?
I have no idea.
Mr. Kravitz, please come forward and be sworn in.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be
What are you
seated.
gonna ask him?
You ask him something.
Okay, Miss Frutt, you may question Mr. Kravitz.
Sir, you were in Judge Aldrich's chambers the day in question for the transaction in question in your capacity as defense counsel for the Environmental Protection Agency. True?
True.
You've been sitting here listening to my version of what happened and to the one offered by Judge Aldrich. Do you have an opinion as to which version is more accurate?
Given that I participated in this transaction as an attorney, I don't feel it's appropriate for me to also bear witness on the events.
We have had a judge bearing witness, sir. It's okay if you do so as well.
Your Honor, I represent clients. I have a duty to
This
those
is a
clients.
hearing about the conduct of the officers of the court. It does not concern the interests of clients.
Certainly, if it affects the interests of clients, I can't be compelled to
I
testify.
want to know what went on in that room, sir. You heard Judge Aldrich a short time ago. We have all been listening ad nauseum to Miss Frutt. Whose testimony today more accurately reflects what went on in that room?
The court has asked you a question, Mr. Kravitz.
I believe the truth lies somewhere in the middle.
On whose side of the middle does the truth lie?
Miss Fratt.
Oh my God.
You believe Judge Aldrich was guilty of judicial misconduct? I ask you a question, counsel. Do you believe Judge Aldrich was guilty of judicial misconduct?
I think he conducted a fair trial. But what happened in his chambers after the verdict, while it wasn't blatant blackmail, it was definitely coercion.
May I respond to that?
Go ahead.
I strongly disagree with Mr. Kravitz's characterization. Let's remember, he was in the throes of being smacked with a $72 million judgment. His career was probably flashing before his eyes.
I resent that.
I have the floor now, counsel. His powers of observation may have been on tilt.
But surely not biased. Not against a judge ruling in his favor.
Let me say also, a judge every single day exercises some coercion. Our dockets are jammed beyond repair with claims that have no real merit. This was one such claim. We push, steer, bend, influence, and yes, coerce. We do it every day. If we didn't, God help the mess, not to mention the injustice. The line is a gray one. I submit to you I did not cross it here. The facts underlying this case did not justify a $72 million verdict. I was there at the trial. I heard the evidence. This panel did not. There was no abuse of my discretion. The knockdown number was fair.
The knockdown number is knocked out. The award of $72 million is reinstated. Defense is free to bring a new motion to remit once the case has been reassigned. We are adjourned.
I'm afraid to celebrate.
Very wise. The 72 will still get chopped down. We're gonna do some research and come up with a number to try and settle.
Okay. Wow.
Yeah.
Josh.
Jimmy. I shouldn't be talking to you. Doctor, patient.
Yeah.
Partial placental abruption. Placental lining started to come loose from the uterine wall.
Coke.
She started bleeding, had enough sense to call EMS, went into shock.
The baby?
We delivered. Little girl. 3.5 pounds.
She all right?
It's too early to tell. She lost oxygen because of the abruption. We're gonna do a cranial ultrasound, check for a stroke. And there was cocaine in her body. Some agitation, maybe withdrawal. We had to notify social services.
sorry, Jimmy.
You just rest.
They won't let me see her.
Later.
Is she okay?
We don't know yet. The doctors are hoping.
They're gonna take her away from me, won't they?
It's too soon to know anything, Jennifer. Just try to get some rest.
Don't let them take her away.